So you're arguing to me that with all what this is legitimately 4 and 5.
Hold up, did you catch that? 4 or 5 charges already, and he's still out here rolling the dice? Imagine being the judge trying to figure out if this guy's a danger to the community.
With another one pending in Wayne County, and he's still using. You're saying it doesn't show to me that he's a danger to the community?
I think if he was driving, Assistant Public Defender Ben Denwick on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart.
What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
Report in receipt of the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor. And I understand that the defendant was released from jail on September the 2nd, went to Community Corrections.
It's not looking good for him. Interview. Whoa. That's not just a red flag. That's a whole fireworks show. Cocaine, THC, benzos, and Suboxone? At this point. The question isn't if he's using, it's how he's still standing in court.
Corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check X jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. So it's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use, maybe.
Here comes the defense trying to thread the tiniest needle possible. Maybe the drugs were from before bond, so technically not a violation. Legal gymnastics at its finest. What do you think? Legit argument or desperate reach?
6 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument. But
can I have just a second, Your Honor?
sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those,
What?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, since I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine.
I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Chills. The judge just said what everyone's thinking. It's not if, it's when. And when happens, innocent people could pay the price. This is the heart of why bond decisions matter.